Hello and welcome to my lecture on data privacy awareness. The objectives of my talk today would be to introduce the following concepts: the Data Privacy Act of 2012, data privacy principles, the privacy impact assessment, as well as the relevant details of our data privacy policy. Another objective would be for you to be aware of these concepts and apply it to your workplace. Okay, so we begin with the Data Privacy Act of 2012, which is an act protecting individual personal information in information and communication systems in the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. So what is important here to remember is that we protect the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. So the protection of privacy is not incompatible to the fostering of free flow of information towards innovation and growth. So the National Privacy Commission is an independent body which administers and implements the Data Privacy Act and is attached to the Department of Information and Communication Technology. The functions of the NPC are the following: rulemaking, advisory, public information and education, compliance and monitoring, complaints and investigation, and enforcement. And we are fortunate enough to have been visited already by the Compliance and Monitoring Division of the NPC when we sought their assistance towards the implementation of this act. So what is data processing? Data processing is any operation or any set of operations performed upon personal data, including but not limited to the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure of or destruction of data. So essentially the whole data life cycle, which we will be touching on later. Data processing is not only limited to the electronic realm. We have manual processing of data as well, no? So other key terms, one is data subject, the individual whose information, personal, sensitive, personal, or privileged is processed. Personal information controller, which is a person or organization that controls the processing of personal data or instructs others to process personal data on its behalf. And that another entity would be your personal information processor. And the data protection officer is responsible for the overall management of compliance to the Data Privacy Act. So the PIC in this case is our hospital, represented by our medical center chief. So what is personal information? It refers to any information from which the identity of an individual is apparent or can be reasonably and directly ascertained, or when put together with other information would directly and certainly identify an individual. So for example, of course, obviously is the, a name would be personal information. If you combine something like a person's age, person's sex, and a person's address, you can reasonably ascertain that there is a person with that age and gender residing in a specific address. So that can also be considered in combination as personal information, no? So what are the criteria for lawful processing of personal information? So you have your consent, which is the first and foremost criteria. If you have a contract with the individual, if it serves vital interests like life and health, if there is a legal obligation to do so, if it is prescribed by law, or if there's a national emergency or for public order and safety, if it is a constitutional or statutory mandate of a public authority, and if it serves the legitimate interests of the PIC or third parties. So, what is sensitive personal information? Sensitive personal information refers to an individual's race, ethnic origin, marital status, age, color, religious, philosophical, or political affiliations. Most importantly for us, health, education, genetic, or sexual life, as well as proceeding for any offense committed or alleged to have been committed, government issued ID, so your GSIS, your PhilHealth, your TIN, that is actually considered already sensitive personal information, and those established by an executive order or act of Congress to be kept classified. So again, you have criteria for lawful processing of sensitive personal information. First is consent. Second would be existing laws and regulations. 3 is to protect your life or health. 4 is processing by non-stock, non-profit organizations. 5, and important for us, is medical treatment. And 6, it would be lawful rights and interests in court proceedings or legal claims. So why do you need to have a lawful basis in processing your personal information and your your sensitive personal information? We have the following violations, which are in the Data Privacy Act. These are criminal offenses. First would be your unauthorized processing. So the person that is processing the data is not authorized. Second would be accessing due to negligence. So the PIC was negligent in protecting the data. That's why it was accessed improperly. Third would be improper disposal. So if you throw away your census, for example, with the name and the diagnosis of patients, and that would be discovered and complained to, so that would be grounds for improper disposal of data. Fourth would be processing for unauthorized purposes. So for example, you gave your number to a loading station, and then 5 days later you would see that there are people texting you about an opportunity, and they were able to get your number from the loading station. So if you can actually prove that the loading station gave your number, then that would be considered processing for unauthorized purposes. Another would be to have a piece of your information photocopied, and you did not authorize it through consent. For example, another department would be photocopying your data, and it is processed, then the PIC can be liable for processing for unauthorized purposes. Unauthorized disclosure would be when someone who is not authorized actually discloses the data. Concealment of security breaches, if there was a breach and that resulted to loss or disclosure of personal or sensitive personal information, and it was concealed by the PIC, then especially for this is applicable for sensitive personal information, so there will be a liability for that. Unauthorized access or intentional breach. So if someone, for example, an ex-employee would be able to access personal or sensitive personal information and uses it, then the PIC can be liable for that. Malicious disclosure, for example, if you obtain a knowledge of another person's diagnosis and you maliciously disclose it over social media, you can actually be liable for this. And there's a new additional guidelines on administrative fines. So the violations earlier in the act, it would need to be litigated in court, and of course the justice system would have due process, no? But the NPC, as its role as a quasi-judicial body, regulatory body, they have issued guidelines on administrative fines that they can themselves impose on institutions as well as those that keep significant records, no? So of course you would think that this capture is sloppy, no? But I wanted to capture the first part, which actually says that the fine, administrative fine, will not exceed 5 million pesos, no? But for grave infractions, it can be subject to institutions can be subjected to administrative fines of 0.5 to 3% of the annual gross income of the immediately preceding year for violations of Section 11 or Section 16, or repetitions of the same infraction. For major infractions, that would be reduced from 0.25 to 2%. For violations of Section 11, Section 16, or Section 20, and other infractions, you have an administrative fine of not less than 50,000 pesos but not exceeding 200,000 pesos when you fail to register the PIC, the data processing system, or information on automated decision making, no? So we are actually mandated to register the data processing system or information on automated decision making, no? So if we violate any order of the commission, we will be subject to an administrative fine not exceeding 50,000 pesos. So relevant sections, Section 7A mandates the NPC to ensure the compliance of the PIC. Section 11 and 16, which were cited in the grave infractions, would be your general data privacy principles and the rights of the data subject. Section 20 deals with the security of personal information, so the security measures that we need to implement to protect personal information. Section 24 was mentioned in your major infractions. It essentially says that government contractors that would process data in behalf of agencies must register with the National Privacy Commission regarding their data processing systems. And Section 30, which is an exception for the for one of the infractions, would be concealment of security breaches involving sensitive personal information. Okay, so the Data Privacy Act is not really to scare you, no, but we have a simple set of primary obligations. Easier said than done, of course. But essentially, for every one of us, we will just need to do this or to accomplish these primary obligations, no? So first is to adhere to the data privacy principles of transparency, legitimate purpose, and proportionality. Second would be to uphold the data subject rights as listed there. And third would be to implement security measures, organizational, which is your policies and procedures. Physical would be your keeping records under lock and key, limiting physical access. And technical would be your encryption, data centers, redundant disaster recovery, etc., etc., firewalls, and etc. Okay, so the rights of the data subject, we will be tackling them one by one in the succeeding slides. No? So the right to be informed is a data subject has the right to be informed whether his or her personal data is or will be or has been processed, the description of the data to be entered in our systems, purposes for which they are being or will be processed, the basis of processing when processing is not based on consent. So that emphasizes that consent is the superior purpose for data processing. So if you can obtain consent, then that is actually preferred, no? And the scope and method of processing data. So the data subjects would also have the right to be informed of who would be receiving data, for example, regulatory agencies, DOH, etc. Methods for automated access, logic involved, significance and consequences of processing, the identity and contact details of the PIC, the period of storage, and the existence of their rights as data subjects, including the right to access, correction, objection to processing or further processing, and lodging a complaint with the NPC. Okay, the next right would be the right to access. No? So the data subject has the right to access the contents of the data that we have processed. No? They can inquire on the what data we are processing for them. No? The source of their data, the names and addresses of recipients, as well as the reasons for disclosure. For instance, we are sending their details to PhilHealth, we are sending some of their details to the DOH, etc., etc. The manner of data processing, whether electronic or manual, information on automated decision-making processes, the date when the data was last accessed or modified. So that means that we have to have audit trail in our systems, as well as the designation, name, and address of the personal information controller. Data subjects' right to correct or rectify is pertains to their right to dispute any inaccuracy or error in the personal data and have the personal information controller correct it immediately and accordingly, unless the request is vexatious or otherwise unreasonable. So the explanation for this, or the best example for this, is what we do in the admitting section if they or if either the patient or the responsible companion discovers an error, or there's another responsible companion that says that my patient's birthday is one day before or one day after, then the admitting section would require proof of that. So for instance, a birth certificate or any ID that would show the birth date, for example. Also with the name, spelling, etc., etc. So if there is a legal document that would prove that the data entered initially in the system is incorrect, the admitting section would require presentation of that legal document, no? In order for them to correct our records. The data subjects have the right to erasure and or blocking. No? So that means that we need to block or remove their data upon proof that the data is incomplete, outdated, false, or unlawfully obtained. The data is used for purposes that are not authorized by the data subject. So if it is found out that another department is using data without authorization by data subjects, then that data subject can block that data processing or remove the data from the system. No? If the data is no longer necessary for the purposes for which it was collected, the data subject can have it removed. And if the data subject withdraws consent or objects to the processing with no other legal ground for processing, then they can block further processing of the data. No? So in our case, we are always governed by the principle of having to use patient's data for medical treatment. No? So that's one legal ground. No? But again, I emphasize that if we can obtain consent, that's preferred. No? So in emergency circumstances, when you cannot obtain consent and it concerns the life or the well-being of that patient, and then you can process data without consent. But if the patient is competent, then I don't see any reason why we can process. We will continue processing data without their consent. If the data concerns private information prejudicial to the data subject, they can ask to block further data processing unless it is justified by freedom of speech, of expression, or of the press, or otherwise authorized. If the processing is unlawful, which means that we did not obtain consent or it's not for medical treatment, then data subjects can ask to have the data processing blocked. As well as if we, as PIC, violated the rights of the data subject. Okay. So the right to object means that the data subject objects to the processing of data unless if the personal data is needed pursuant to a subpoena issued by a judge, no? Or if the collection and processing are for obvious purposes. So as earlier mentioned, medical treatment is an obvious purpose for our patients. If the data is necessary for the performance of or in relation to a contract or service, then that could also be an exception to the objection, no? As well as an employer-employee relationship between the collector and the data subject. No? Again, it's better that we have consent. So if you recall, the Human Resource Management Office has asked you to sign consent for processing of government-issued identifiers, because it's better that we have consent for that, no? Rather than relying on the employer-employee relationship. No? So it's clearer, no, that we are using or we are processing government-issued identifiers such as your PhilHealth ID numbers with your express consent, not implied consent, or not relying on the employer-employee relationship. Data subjects have a right to damages, no? So they can be indemnified for any damages sustained due to such inaccurate, incomplete, outdated, false, unlawfully obtained, or unauthorized use of personal data. So aside from litigation that they can sue for damages, they can also be settled, no, out of court, for example, or settled as part of an agreement, no? So they can be indemnified by the institution itself. So the right to data portability is for data processed electronically, and data subjects must be able to obtain from the PIC a copy of the data in an electronic or structured format that is commonly used and allows for further use. So the best example for this, unfortunately, I don't have Facebook, no, but I know that Facebook has a function wherein you can obtain a copy of your data on Facebook. So essentially that is to fulfill this right. So if you are able to obtain a copy of your Facebook data, you can use it somewhere else, no? Because it allows you to obtain your pictures and messages, for example. Here. And then you have the right as a data subject to file a complaint. No? So if your personal information has been misused, maliciously disclosed, improperly disposed, or any of the data privacy rights have been violated, then you have a right to file a complaint. So the National Privacy Commission has its own rules of procedure. It involves informing the PIC first that you feel that your data privacy rights or the rights of someone else has been violated, and they will need to act on it. And then after that, if there is no satisfactory action, then you can file a complaint with the NPC. Okay, so the data privacy principles, there are only 3 and they're listed on the screen: transparency, legitimate purpose, and proportionality. And these are really important, no? So what is transparency? The data subject must be aware of the nature, purpose, and extent of the processing of his or her personal data, including the risks and safeguards involved, the identity of the PIC, rights as a data subject, and how these can be exercised. No? And the information on data processing must be easy to understand and accessible, and the data subject must have reasonable access on demand. And for electronic data, they can access a copy in the structured format, data portability. So, right to be informed, right to access, right to photo data portability. That essentially is transparency, no? And a privacy notice goes a long way to implementing or to to implement the principle of transparency. No? So a privacy notice includes a description of the service, the personal data to be collected, the method of collection, the timing of collection, the purpose of collection of data, as well as the method of use, storage and transmission, as well as the location of data, third-party transfers if applicable. So we transfer data to other institutions such as your PhilHealth and DOH. Information requirements, retention period. So we followed the retention schedule from the National Archives of the Philippines. Participation of the data subject or how consent is obtained, and the contact information for inquiries or complaints. Okay, so legitimate purpose. Legitimate purpose means that the processing of data shall be compatible with a declared and specified purpose, which must not be contrary to law, morals, or public policy. So declared, no? Declared, not implied. So the meaning is really specific, no? In emphasizing that there must be a declaration of purpose. And that declaration of purpose must be in our consent, no? Data subjects must exercise control over how data will be used, and consent requires a freely given, specific, and informed indication of will, evidenced by a written or electronic record. So that's why during admission we have consent for data processing, that we have our patients or our responsible companions sign. Consent must be unbundled from other terms and conditions. So that means that this is not a hard requirement for them to be treated, no? You have actually cases wherein patients, Mr. or Miss X, unfortunately, are brought to the ER or the emergency department, that are obtunded, and you cannot obtain any information from them, any consent even, and you rely on any identification in their wallet, for example, just for them to be registered. And that doesn't mean that if you cannot identify them, you wouldn't be able to treat them. So that's essentially an example of that bullet there. No? Very important is this bullet, no, implicit or negative consent is not recognized. So consent is explicit, no, and it's not supposed to be implied, no. So it doesn't mean that if you've signed the consent form, it's not indicated that any other department that doesn't have the mandate of keeping your records will also process their data. Then it's implied because they signed the consent, that's okay. I think that's a very big mistake, no? So we need to obtain a consent whenever another department that does not have the mandate process the data. Okay, so proportionality. So processing of information shall be adequate, relevant, suitable, necessary, and not excessive in relation to a declared and specified purpose. So your purpose for example, no, if your purpose for obtaining data or abstracting data would be to fill out a form, but you are obtaining data that is more than what the form requires. For instance, you are already obtaining government identifiers, or you are already obtaining information about the patient's relatives, for example, but you only need a small part of that data for your form. And if you persist on obtaining that, then that means that there is a violation of this principle as well, no? So that's a vague example, but I think you can find that there are some concrete examples of violating that, no? There's actually a case that was elevated to, I think it was the Court of Appeals, that condominium tried to obtain excessive amounts of data, no, for in the guise of protecting their residents, no, but it was found out that the excessive processing of data was not proportional to the purposes that they declared, no, that they needed to improve security in their condominium. So other principles will be data quality, no? We need to ensure that data is accurate, complete, and up to date. So for example, if we have changes in the system, we would prefer it that the data sets from the previous incarnations of the system would still be complete and have no blank spaces or no null values, because we already changed the system, changed the tables, etc., etc. If the data is inaccurate or incomplete, we need to correct it, or add to it, or destroy it, or the further processing is restricted, no? Okay, so we need to implement security safeguards. So one would be your organizational commitment. So the data privacy policy of the hospital is one. The procedures would also be part of that commitment, but they are more on the program controls, no? And third would be continuing assessment and development. So this is actually the role of our unit heads and department heads, no? That they'll need to continually assess their privacy risk and develop measures to ameliorate or to negate these risks. Okay, so we now go on to a privacy impact assessment. The privacy impact assessment is a process to evaluate and manage privacy impacts in an organization's programs, processes, activities, systems, and operations. Why do we conduct a PIA? No? So we need to identify privacy risks and vulnerabilities. We can also use the PIA for us to be able to determine adherence to the three principles of data privacy, transparency, legitimacy, and proportionality. If there are any lapses in organizational, physical, and technical security measures, and to determine how the organization upholds data subject rights. And the end point of the PIA is the establishment of a control framework that will address all these issues, no? If we are able to identify them. When is a PIA necessary? So as baseline, when the NPC visited us, we all of the units and departments created the baseline PIA as directed by the Data Protection Officer, Ms. Monin Goles, prior to implementation of new programs. So in this regard, I applaud the molecular laboratory, which who they created a PIA, no, prior to launching their service. No? Changes to processing of data. So if we migrate from a manual to an electronic method of data processing or vice versa, we will need to do a PIA as well. When entering into a data sharing agreement, for instance, large researches, or for instance, if there's another agency that would need to use our data, you might also need to perform a PIA. And finally, if there's large-scale data collection, institutional research also, so you might also need to do a PIA. What are the benefits of undertaking a PIA? So it promotes privacy awareness. It is a sign of good governance. It is also a sign of compliance. It is cost effective because we are not going to be charged those administrative fines, as well as face litigation for violations of the DPA. It prevents privacy risks, and it identifies privacy strategies. So what are the basic questions that we consider during a PIA? No? So what do I process and how? Do I comply with the law? What are the risks? What can I do about those risks? And when will I reassess? Okay, so we mentioned the data life cycle earlier. The data life cycle is collection. This is according to the NPC. No, the figure here is analogous, but basically the cycle as defined is a collection, use and access, sharing and transfer, storage and retention, as well as disposal. So the Data Privacy Act does not only concern itself with collection of data or sharing and transfers, it concerns itself throughout the data life cycle. No? So in the figure there, you have storage, you have use, you have sharing, archiving, and destroying, and then creation again. No? So it's really a cycle. Okay, so each unit and department must maintain records of processing activities. No? So this includes data inventory. What data do you collect? The data flow. So how does data flow throughout your procedures? The process of processing your data, no? If you obtain consent, the sources and recipients of personal data. So um, who do you obtain it from, and who are the recipients of this data? Accountable and responsible persons. So very important, the accountability, no, of who's collecting the data and who's processing the data. And finally, existing safeguards that you have. So again, organizational, your policies and procedures. Physical would be your limit to physical access, and your technical safeguards. So in conjunction with the MIS, you have encryption, two-factor authentication, backups, firewalls, antivirus, etc., etc. Okay, so that's the first part of my presentation. The next part would be the salient points of our data privacy policy. So I have already edited, and I think in another video on my channel, I've talked about the experience of rewriting the data privacy policy into the new template. And that new template allowed us to enumerate policy objectives, no, for the data privacy policy. So first objective is to uphold the data rights of all data subjects of the hospital. Second objective would be to comply with the provisions of the Data Privacy Act. It's implementing rules and regulations, issuances of the National Privacy Commission, and other regulations related to data privacy. Third objective would be to foster and maintain awareness on data privacy, including how we safeguard data privacy rights among employees and data subjects. So this video is towards that objective. And fourth would be to minimize, if not eliminate, risks that threaten data privacy rights. So of course, linked with those objectives are activities, so the privacy notice, awareness building activities such as this one, monitoring of compliance, the privacy impact assessment, the development and implementation of data privacy procedures by units and departments, and these should be relevant to their mandate. Data inventory, data flow, stated lawful purpose, sources and recipients of data, accountable and responsible persons, and existing safeguards. The procedure on data breach response, so currently it's a policy, it will be rewritten as a procedure. The data privacy committee, and the evaluation of data processing activities, and forwarding of relevant recommendations to the concerned personnel. No? So the most important people in our data privacy strategy would be our unit and department heads. No? So first of all, they will be responsible for being aware where our privacy notice is. No? So we have a privacy notice physical form that is at the admitting section, and we also have it on our website. If you want to print out a copy and have it accessible in your work area, that's fine too, but at the very least you should know where it can be accessed. Second would be awareness building activities. So aside from this video, the heads can initiate on their own initiative, hold activities that will build awareness on the Data Privacy Act. Of course, monitoring of compliance must be part of your regular workflow, and unit and department heads should conduct PIA with the earlier what I mentioned, the as baseline, etc., etc. Unit and department heads are the best people to assess privacy risks. Therefore, the knowledge of risk would enable them to develop and implement data privacy procedures that are relevant to their mandate. And data processing activities of the unit or department, as well as data privacy and security activities, must be documented. So our medical center chief is by default our PIC. However, he or she can designate unit and department heads, and as a result, the responsibility as PIC will also be designated to them. The PIC determines privacy risks, so the unit and department heads are the best people to determine privacy risks in their area of responsibility. Of course, the medical center chief designates or recommends a data protection officer as well as the data privacy committee composition. Okay, so the role of the data protection officer, these are from the National Privacy Commission, is level 1 program, no? So first, the DPO must have no conflict of interest. So as much as possible, the data protection officer must not be in a role wherein he will provide guidance or any policy decision making that may conflict with his role as a data protection officer. For example, if the data protection officer is placed as head of IT, the tendency for the DPO is to conceal or hide any issues that the IT section might have, no? So that's why DPO must ideally be an officer of the institution that does not have any other responsibilities, no? Second would be the DPO must be independent, that has autonomy over decision making, no? And the DPO is bound by confidentiality and secrecy. The DPO's opinions have due weight according to the NPC. The DPO monitors compliance, ensures that a PIA is held, and advises the PIC. And the DPO is also tasked to cooperate, coordinate, and seek the advice of the National Privacy Commission. So for our hospital, we have a Data Privacy Committee with the chairman, chairperson, in our case, Ma'am Yin Goles. Unit and department heads are members of the committee by virtue of their position, no? And we have a dedicated data breach response team. Right now, since with the rewrite of the policy, we have designated or delegated the tasks of awareness building to the unit and department heads. Aside from this video, then the training and awareness team is now defunct, no? So the role of the Data Privacy Committee is one, compliance, of course, monitoring and ensuring compliance along with the DPO, along with the DPO to conduct a PIA. The data breach response team is responsible for our security incident management. The committee is also to encourage the awareness building, and 5 is to participate in policy development and review using a privacy by design approach. So within the policy itself, the policies are designed with privacy in mind. So that when implementation comes, the issues or the risks in violating the data privacy principles or not upholding the rights of the data subjects, these are minimized already because the policies have been developed with privacy in mind. So we run through some essential principles. The privacy mission of the hospital. We are committed to delivering health services effectively and efficiently while protecting the data privacy rights of its patients, employees, and other data subjects. So the rights of our patients as well as our rights too as employees must be protected. So the hospital meets the standards of data protection that our patients, employees, and other data subjects are entitled to, as well as the needs and expectations of our clients regarding health care delivery. So the hospital recognizes the value of data in research, training, and policy making for service delivery and will not impede its proper and lawful use provided that adequate safeguards are in place and data subjects are upheld. The hospital and its employees must be constantly vigilant in protecting the sensitive personal information of its data subjects, and care in handling information must be built into the processes and procedures of each unit and department. The hospital and its professional staff recognizes the privileged information handled during patient encounters and shall ensure the protection and care in handling this information. The hospital commits to upholding the data privacy principles. So again, a privacy notice for transparency, legitimate purpose. So the declared purpose must be known at the time of collection or made available at any point during the patient encounter. And proportionality, the method and extent of data processing shall be aligned to the legitimate purpose that was declared. Okay, so the hospital commits to upholding the rights of the of our data subjects. We've already tackled that earlier. And our different units and departments commit to conducting a privacy impact assessment during the following period. So I've also talked about that earlier. The units and departments will keep a record of all data processing activities throughout the data life cycle, and this includes the following, no? Okay, so we need to implement various security measures, organizational, physical, and technical measures. We maintain a security incident management program, which includes breach management. We need to ensure a comparable level of protection when personal data is being processed by a third party, and require appropriate data sharing agreements as well as confidentiality agreements. And ongoing training and awareness of data privacy principles, rights of the data subjects, and data protection procedures. So I think that's my last slide. Thank you for your attention. I know this has been a very long video, but I hope this video allows you to have a bird's eye view of our data protection processes, procedures, principles in our medical center. So again, thank you and have a great day. And if you have questions, I am very much welcome to address them. You know where to find me in the hospital. And again, thank you for your attention.